Thank you, Professor Philippe Collette and SOAS for giving me this opportunity to make a presentation on a subject which is really gaining a lot of importance, gaining a lot of criticality and a lot of contentious issues. This is my first visit to SOAS, and I just said it looks so vibrant and it looks full of life, full of color, and you don't see up north that much of diversity or that kind of, commitment towards environmental issues, particularly in my law school. My talk today is essentially on environmental adjudication in the Anthropocene. I work on environmental issues, but of lately, for the last 5 or 6 years, I've really focused on the nature of adjudication, and that's where the National Green Tribunal has come up. Adjudication in the present day time has really become a contentious issue because it's just not about adjudicating the law. It's all about finding solutions to the environmental problems. Every now and then, whenever we go to a conference or when we are sitting in the meetings, at a global level, there is one perception which emerges or one school of thought which comes about, and that is implementation is a huge issue. We understand, yes, implementation is a problem. But then there is also a duty on the parts of the court to come out with practical solutions which could really provide the basis for solving these problems. And that's where the topic of environmental adjudication becomes important. The way I have structured my talk is, it's about 35-40 minutes, and I'll try to introduce about what is Anthropocene. Then I move on to talk about the importance of judiciary in the Anthropocene. I try to identify approaches that can be taken up, but more importantly, I focus on procedural innovations with emphasis on India. I'm an Indian-born British professor, yes, but my roots are very much there, and I work on India issues. And I couldn't have got a better opportunity than SOAS to make a presentation of my work. Because when you cannot read or understand environmental issues from one domestic jurisdiction. There's a lot of overlapping which goes about, and therefore it's very important that we take up good practice examples to be inculcated in the different legal systems, whereby finding solutions to the problems. So I'm using India as an example because it's considered as one of the good practices examples from developing countries which is trying to tackle environmental issues. This is not to say that India does not have problems, it definitely has problems, but then at the global level it presents itself as a good example. And then I have some concluding observations. The question is, have we entered the era of Anthropocene? And it is debatable. Because some people say we are still in the era of being in Holocene, whereas many of the people, now scientists, have started saying that we have entered into the era of Anthropocene. Anthropocene is an era, it's a geological epoch which is triggered by human activity. And this human activity has essentially led to disruptions in the Earth systems. The very self-regulating Earth systems has failed to function, and as a consequence, the safe biophysical limits have been crossed, which have ultimately resulted in problems like climate change, extinction of species, pollution-related issues, and there is no way that we can go back to having a clean and an unpolluted world in existence. So from 2000 onwards, the terminology of Anthropocene was being developed, and by and large, scientists have come to the conclusion that yes, we have entered into a new geological epoch. The consequence of this new geological epoch has been that it has created inequality in the world and ultimately led to a lot of environmental degradation. It's the people as well as the nations who are at the suffering end. And if one looks into the statistics, one finds, yes, there are real associated problems impacting on the lives of the people as well as on the nations, affecting both the present and the future generations. If I go by the statistics, 20% of the world's population consumes 80% of planet's resources. In 2015, 62 individuals possess the same wealth as the world's poorest 3.6 billion people. 750 million people have no clean drinking water, which are not there in the developing countries or in the underdeveloped world. The small island states are the most ecologically vulnerable because of climate change issues that are coming. And this sort of research is really gaining a lot of momentum. Corte has done, Gonzalez is talking about it, and we can find a lot of statistical data which really figures out that yes, we have entered into the Anthropocene. And that's where it becomes important that we start revisiting the legal and the governance discourse. Because what is important for us is to look into how policies, laws, and institutions are going to work together in order to give environmental justice. And when I'm talking about institutions, particularly I would be focusing on the role of the judiciary or how the courts are going to play an important part or are playing an important part in this Anthropocene era. What we want is a judiciary which is specialized, responsive, and transformative. We do not want judges who are only confined to the regulatory framework. Because when you are confined to the regulatory framework, when those barriers are coming, the reliefs which you are giving is either facilitating or mitigating an industrial activity. You're not going beyond that. This is the legislation, this is how you're going to divide, and these are the rights and the liabilities of the parties coming. But you don't go beyond that to look into how a future problem can be solved. And I'm going to bring in here a very important point about Brexit. Brexit and environmental issues at this moment are facing this challenge. Because the whole of the UK is so entwined with the European law that the real question comes, how are we going to decide this? Can we be outside this? And the debate is going upon what should be the nature of environmental courts and how should the judges be taking this forward? And the reports are suggesting that this is a moment of opportunity that the British judiciary must take into account. It should not confine itself to just a regulatory framework, a limited scope, but it should go beyond to expand its horizons, to look into ways of solving the problems which are very much transformative in nature. And that is why the nature of adjudication takes the shape of progressive initiatives. So we need to have progressive initiatives to be in place which provide innovation. And this innovation can always be coming up when judiciary interacts with the scientists. Scientific interventions, economic interventions from economists' perspectives become very important to solve the environmental matters. Environmental law per se cannot be judged only by legal principles. What you need is an interdisciplinary, holistic approach that would be solving the problems. And that is why innovative ways, transformative approach is the need of the hour in terms of solving environmental issues. This kind of approach, transformative, has been really talked about since 2002. The Johannesburg Principles on the Rule of Law, the United Nations Environment Programme on Global Judges, the World Congress on Justice, Governance and Law for Environmental Sustainability, and the Bourbon Declaration in Pakistan, which talks about these elements. Together they are talking about, and that's where I've taken the clipping, together they are talking about accessible, fair, impartial adjudication, which should involve dispute resolution mechanisms, specialized expertise, and innovative environmental procedures and remedies. So there is a movement which has started at the global level where the judges are talking about, or where the international organizations are insisting that it is the time which has come where judges should play a very important and a critical role in terms of solving environmental disputes. So therefore, specialized expertise, impartial, accessible justice becomes central in terms of environmental matters, which ultimately leads to maintaining the concept of environmental rule of law. This kind of transformative judiciary, or an important judiciary, is very important in systems where we have both common law and civil law legal systems operating. And more importantly, they become important in countries which had the colonial culture, the British Raj, which was there. You talk about small island states, you talk about India, you talk about Pakistan, you talk about South Africa. All these nations are reeling under a lot of problems, and therefore the role of judiciary becomes important. What these nations have taken from the British Raj has been a Westminster model, the tripartite checks and balances that are operating. It works in some ways, but in many ways it has a limited effect. And what we see now is a three-legged stool has become a one-legged stool. The executive, legislature and judiciary were there in a Westminster model, but in many countries the executive and the legislature has not been able to perform very well, which has ultimately led the judiciary to take the mantle of providing justice to people. When it comes to India, I hate to say that, but that's my view, and please excuse me for that. All Indians, everyone, but I would like to say I have a very favorite line. I sometimes feel India is a nation of anarchists masquerading as democrats. They keep on doing everything, but they say we are democrats, but they are not. If you look at the parliamentary system, 1/3 of the members of parliaments have got criminal records against them. It's not a problem of India, but it's a problem which is there at the global level. You have an ineffective legislature and executive, corruption is rampant, the bureaucracy is indifferent, and there are lack of resources and skills to really look into the problems. And then the only masiha which comes about is judiciary. Judiciary in many countries have started playing a proactive role. And I'm very careful with the word proactive, because often there is a very thin line of demarcation between judicial activism and being proactive. And sometimes we are bordering on whether it's judicial activism or proactivism. But what is needed in today's time is a proactive judiciary which enhances public image and the issues of legitimacy. So therefore, fairness, integrity, objectivity, and impartiality these are the values that are very much needed for a judiciary to become proactive in nature. And once you have a proactive judiciary, the transformative process, the radical approach, the innovations automatically would come into picture. In terms of how this would go forward, I'll just briefly touch upon, there are 3 ways by which we can identify that judiciary can play a very active role. One is transjudicial communication and transplantation by judiciary. The second is reconceptualizing the environmental law. And when I say reconceptualizing, it's in terms of nature. Where does nature stand? And the third is integrating science into environmental decision making. The first one is transjudicial communication and transplantation by judiciary. This is very important in present day time. Sharing information and adopting good practices always brings in or inspires solutions to environmental problems. It is a way whereby a pluralistic and contextualized understanding of environmental issues is fostered. Through comparative legal analysis of different judicial experiences, the judges or the judiciary are able to identify common sets of competencies, procedures, and remedies. So the judges can, despite the fact that they are working in different legal systems, but sharing of information can be very, very helpful in terms of solving environmental matters. This is not to say that legal systems are not different. Yes, legal systems are different, but then there are certain common problems which are existing at the global level. For example, pollution. Pollution is everywhere throughout the world. Similarly, you've got misuse of technology which impacts on environment and the health of the people. Now, these are very much issues which are in existence, and therefore it becomes important that the judges, through interactions and communications and through legal transplantations, try to solve the problem. And I particularly like Judge Veeramantri. Have you heard about him? He was the ICJ judge, very, very famous ICJ judge. He said judges always have leeway of choices. In every legal system, there is a foundation, and this foundation can be used to adopt good practices from one system to another system. And that's where he gives a very good example. He said, customary practices were never recognized in international law. But over a span of time, the nation started recognizing, and automatically it started developing as a customary international law principle. The same is applicable in terms of environmental matters. There are the principle, the precautionary principle, polluter pays principle, public trust doctrine, right to environment as a human right. All these are examples which came up in different jurisdictions, but then automatically, over a span of time, all these in some form or the other have been incorporated in the different national legal systems. And essentially this has been done because the judges have drawn experiences from the other countries, and as a consequence, they have adopted into their system. And that is where tailoring becomes a norm. You cannot copy and paste one principle applied in one jurisdiction to another. because the cultures are different, the economic conditions are different, the societal impact is different. What you do is you tailor make those norms and then adopt it into your own culture. This essentially helps in judicial capacity building, multilateral exchanges taking place, and credible responses to environmental problems. I'll take one simple example. In 2016, there was this conference which took place for Asian judges in Singapore. But judges from UK, judges from America, judges from Australia, judges from Brazil, all were participating in these conferences. And they were trying to share the best practice examples of how to solve the climate change problem. Climate change litigation is becoming a huge issue. So therefore, sharing those best practices examples in relation to mitigation and adaptation were very, very helpful in terms of applying those legal principles to climate change litigation. Reconceptualizing environmental law in today's time has become a very topical subject. There has been an incremental shift now from anthropocentric approach to a biocentric or an eco-centric approach. The question really comes about is, how do we assess nature? Is nature a property or is nature a legal entity? Because under the anthropocentric approach, nature has been regarded as a property for the benefit of the humans. The intrinsic value of environment has never been taken into consideration, and that is why now time has come when people have started talking about that the nature should be assessed as a legal entity on its own. And that is why you can come across, I'm sure you must have read these examples which are coming upon, Ecuador and Bolivian constitutions are recognizing nature as a legal entity. The judicial precedents in New Zealand and India, where they are saying river is a living entity, are also coming up. And that really goes very well with legal transplantation. Because in all these cases, in 4 different jurisdictions, the cases are being cited from other jurisdictions to talk about, yes, nature should be given a legal entity on its own. No doubt these judgments have come about, but I feel that the divide between the rhetoric and the reality is so deep that it becomes difficult in its practical implementation. For example, the Ecuadorian Constitution. It recognizes nature as a legal right. In 2007, there was the Tipotini initiative that was being taken, where the President Correa, he said that yes, we will not exploit our oil resources in a national park. But then he entered in an agreement with international organizations and he said, if the international organizations give me $3.6 billion, I will not exploit these resources. The United Nations and other organizations entered into an agreement and they said that we will give you the money, but you don't exploit these resources. The oil, you don't do that. However, till 2013, the Ecuadorian government did not get any monetary compensation or any monetary award from these international organizations. And consequently, in 2013, President Correa withdrew from the agreement and started exploiting all these natural reserves. Because the competing values of development and poverty became very important. So the point which I'm trying to make is, yes, we do talk about protecting nature, but then when it comes directly in clash with competing interests about development, then it becomes very difficult for countries to really take a stand on those issues. Again, in India, river has been identified as a legal entity. But the question is, there are lots and lots of questions associated with it. The High Court of India comes out with a judgment, but the matter is already pending in the Supreme Court and in the National Green Tribunal, which is a specialised court. The first problem which comes is jurisdictional issue. And I think this kind of a judgment has been a case of judicial activism rather than a proactive judiciary. The second problem comes, whose rights are we talking about? This judgment says Ganges has got a living, it's a living entity. But if you look into it, Ganges is the most engineered river on this planet, with maximum numbers of dams, with maximum number of irrigation projects, as well as millions of tube wells which are there. How do you interpret, whom do you prosecute if the river, if there is some sort of a damage which is caused to the river? What happens when river gets flooded and it destroys people's lives and people's homes? Now these are debatable issues which come up in terms of practical implementation. But having said that, this is a good move, because what has happened is, rather than making man as central in everything, there is an awareness which is coming about in trying to understand that ecology has got its own existence. And harmony with nature is very important in the present day times. So it's a step forward, I would say. It's thinking positively and bringing nature as a central focus in trying to decide about the matters. The third important thing is integrating science into environmental decision making. There's a lot of literature and there's a lot of statistical data which shows that most of the time judges come from social sciences background. And as a consequence, they are not able to really understand the complexities of science. Environment is so interdisciplinary, it has a lot of scientific elements coming into its fold. And that is why it becomes important that it should not be only the legal people deciding the matter, but it should be the scientists who should also play a very important role in environmental decision making. Increasingly, this subject is so complex and technical that in order that we have good environmental results, we must include good science and experts. What usually happens is judges lay open to junk science, because both the parties are coming and both the parties are bringing evidence of science. And the judges are confused because they are not from scientific background. So the best way forward is that scientists should be central in the decision-making process, because they can really understand what is happening. And once they start understanding, you can then think about innovative ideas coming and innovative decision-making taking place in that process. The road to dignity, the Sustainable Development Goals, also the report is clearly stressing upon the fact that in order to solve these issues, a science-based approach has to be adopted and an action-oriented agenda needs to be taken into account. So therefore, the point which I'm trying to make is that in the present day time, when we are talking about Anthropocene and the present day time, the interface between science and law is very important. I'm really not going into the question of science and policy making, because there's a lot of disparate kind of a literature that is available. But what I'm saying is that in decision making, in adjudication, scientists and legal experts should sit together in trying to solve the issue. Because that is the way forward in terms of applying different kind of scientific methods and approaches, and also interpreting the principles of international environmental law. We use, if you look at the judgments, the terminologies which are being used, and I'm sure you must have read these cases: risk assessments, risk management, adaptive management, ecosystemic approach. All these the judges will not be, if you are just from a legal background, you will not be able to really make out what these issues are. And that's where the need of experts comes up. There's one concept which is really emerging in science, and it's being used in there are hardly one or two cases where it's being used, which is known as energy synthesis. It's not energy, but it's energy synthesis. It's a very new concept, but then it's talking about valuation of environmental goods. How do you value these environmental goods? By taking a scientific expertise. And there is one professor in America who's really started doing work on energy synthesis, where science and law, the intersection of science and law is taking place. Coming to procedural innovations, where I'm really going to focus, Goal 16 of the Sustainable Development Goals is talking about, you know about, that access to justice has to be given through effective and accountable institutions. But if you really look into it, do you agree that access to justice is being given? Do you believe in that? What is the position in your countries? Is it available in the UK? The answers are no. Whichever country you might take, access to justice has become a very debatable issue. First of all, in the developed world, it's very difficult to identify who's public interest. And in the developing world, even if you give the access, the question really comes about is in terms of implementation. By and large, there has been a very limited success in terms of access to justice. There's a very narrow interpretation given. Western world only goes by what regulations are talking about. So it's only for the purposes, as I already said earlier, facilitating and mitigating industrial activity. And most of the time, the applications of standing are discouraged, are not taken up by the court. But in developing countries, again, standing is an issue, but even if they have a liberal one, then the question really comes about is implementation. In the era of Anthropocene, where we are, we need radical transformative adjudication, which is going beyond the statute. It's not confined to what is being written literally in the statutes. It should go just more in terms of really finding solutions to the problem. And that's where I'm taking example of Indian judiciary, which at the global level is considered as progressive and dynamic. India faced the worst industrial catastrophe in the form of Bhopal tragedy. I'm sure you people know about Bhopal tragedy, where thousands and thousands of people were killed as a consequence of gas leakage from a methyl isocyanide plant. People died. But the government was more interested in trying to develop its own industry. But having said that, suddenly environment became a huge issue in India, and public interest litigation emerged as a tool to solve the problem. The public interest litigation, which is there in other countries also, provided speedy, inexpensive, and direct access to the highest courts. So people really went in, affected people, went into the Supreme Court, the highest court of the land, and started getting benefit remedies out of that. Right to life included right to environment, which was taken from other jurisdictions, and it was incorporated within India's environmental jurisprudence. So there was a locking of human rights and environmental issues. No doubt public interest litigation came about, but the question really emerged in the time was, is it a magic bullet? Is it really giving justice to people? Because there was a lot of debate going on, and the problem came about activism versus constrained debate. And the judges were always being labeled as a case of judicial activism. Judges are going beyond their scope and trying to tread into the area of judiciary, or tread into the area of legislature or executive. more importantly, judges were not trained in complex environmental matters. So what happened was that they lay open to this junk science which was being produced by both the parties together. They are of an equal standing. Both of them are judges, both the parties, as they decide the case, and there is an interdisciplinary decision-making that takes place. And if you start reading the judgments, you can see it is not confined to what the legislation is saying, but it is bringing the scientific element into its form. And that's the beauty of new environmental adjudication, which is expanding. If you look into Australian judgments and the New Zealand judgments, again, you'll find that kind of a trend emerging. So it's not about Section 236 of the Planning Act has been violated. No. It talks about how the problem has come about, from what scientific perspective are we going to talk about it, and what are the solutions that can be provided. So it's a sort of an interdisciplinary decision making. And it's the principle of collegiality which is working. When I talk about collegiality, it basically means that the judges are sitting together and deciding about the matter. You'll be surprised to know that, when I went through about 1,300 judgments, there was only one judgment where there was a dissent. The rest of the judgments were based on the principle of collegiality. This is not to say that they do not have disagreement. Judges do have disagreement. But what they try to do it is, in the drafting stage, they try to ensure that these differences are sorted. Why? Because what they feel important is, we need to provide a solution to the problem. Rather than we give a judgment and then it's appealed to the highest court, then it defeats the very purpose of environmental adjudication. You don't want judgments to go on being appealed time and again. What you want is solutions to the problem. So what happens is that even if when they have the differences among themselves, they try to thrash out at the initial stage, and then they try to come out with a proper judgment which has the flavor of both law as well as science into it. So this positive collegiality is always talking about interdisciplinary judgments, because experts are not handmaidens, but they are of equal status, of homologous standing. And what I'm trying to say is, this is the way forward in an era of Anthropocene, where the emphasis is more on finding the solutions rather than just adjudicating based upon what the statute is talking about. In its relation, how they work, and that's where it's becoming important, they give a very broad standing to the people. Anyone can come forward, even a foreign national. There was one case where a foreign national was living there and he filed a case and the court entertained the matter. Because what the court feels is justice should be done, because the inability of people should not be the basis that you say environmental justice should not be provided. More importantly, developing its own procedures, and that's very important. The judges on its own, there are different ways they go about. One is suo motu. They take the cases on their own. It's very debatable. The matter is pending before the court, but the court says, we have seen a problem. Suddenly they are doing mining extraction in a tiger reserve area. Everything happens in India, right? So, or groundwater is getting polluted, or the forest cover is being cut down without following any norms. So the judges take up the cases on their own to solve this problem, and this is known as the suo motu power which is being given. Investigative procedure means that the experts go to the field, and I'm sure Philip would understand that in the civil law systems, investigative procedure is really being adopted by the courts. So the experts go to the field and try to compare and contrast the contradictory claims. Because what they feel is people's lives are getting affected, environment is getting affected. Why go into the court with a brigade of scientific, evidence which has a lot of money involved into it? Let the scientists go into the field, and that's where they have their expertise. Let them investigate into the matter and try to solve the problem. And the last one is a very unique one, which has been really received very well at the global level, which is known as the Stakeholder Consultative Process. Stakeholders are brought on the same table, and they are asked to thrash out the issues. The major issues like air or water pollution have been tackled by stakeholder procedure. Let me show you this example. This is Delhi. This is India. This is air pollution. 8 out of the 10 school-going children suffer from asthma. Last year in November 2016, environmental emergency was declared in Delhi because of the high levels of pollution. The first time when the case was filed for air pollution was in the year 1985. And it has been lingering on, you can think about it, 85 the first time, and now it's 2017, still the matter has not been decided. The specialized court adopted the consultative procedure. Similarly, water pollution, Ganges, Yamuna, they are the most polluted rivers that are existing. On one hand, we talk about right to healthy existence, right to clean water, right to clean air, but that's not available. We talk about present and the future generation. It is not there. This is not a problem only of India, but this is a problem where you have billions of people living. London is facing the problem of air pollution, huge issue. How do we solve that problem? It's only the size, the variance of size, albeit, but otherwise the problems are just so complex and they need solving of these issues. So what the specialized tribunal has done is it has adopted a new technique known as the stakeholders. All the stakeholders are brought on the same table and they are asked to provide solutions to the problem. There are two things which have happened as a consequence of this stakeholder. One has been the authorities from denial mode have gone into an acceptance mode of saying, yes, there is a problem. Otherwise, all the time the authorities were saying there's no problem. But now they say, yes, there is a problem and we need to solve. And the second thing which has happened is that they have started, rather than blaming each other, they have come out with concrete proposals to solve the same. So it's an ongoing process. I'm not saying it's 100% successful, but it's an ongoing process where the authorities, regulatory authorities, affected people, the courts are coming together to solve problems to these major issues which are impacting on public health and environment. So what has happened is there is a greater element of consent rather than opposition to a judgment, because most of the time people are opposing judgments, but now they are agreeing that this is a problem and we need to solve it. And this stakeholder process, consultative, is now being cited at the global level as one of the ways forward to solve complex environmental issues that are coming. It's not provided in the statute. It's not there in the legislation, but it's a process which has been evolved by the courts in order to really solve the matters which are there before it. And the last one which I would say is the court also, which is different from the Western world, it has started coming with prescriptive policies and rules. Usually it is the legislature which lays down the rules, but what happens in a country where the legislature is ineffective? It has not even thought about those rules, or executive has not thought about the rules. Burning of tires is a very good example. You would never see burning of tires in this country or in the Western world, but you do come across these examples in developing countries where tires are burned because you are opposing the government for anything, or you're just trying to ensure that that's the way where rights take place, but there are no standards which have been laid down how these tires would be disposed of. So the scientists are saying, fill in those gaps. We do not have law, or the law is inadequate, so the scientific expertise is going inside of providing standards for this tire disposal. Similarly, noise. How many of you have been to India? Okay. We hear loudly and we talk loudly. And noise, we don't understand that we live in noise pollution. There were no so specific standards which were provided for noise pollution. And then again, the scientists said, on one hand, you're talking of right to a clean environment, which includes right to clean air, which includes noise, but you do not even have so specific standards for that. And I was reading somewhere that the Japanese government took out a policy of saying that when you supply cars to India, you should have the strongest of sirens to be imposed or horns to be imposed, because that's how people listen, otherwise they don't listen. And that is totally against the international standards. And that's where the scientists say, come on, come up with regulations, we need it. Bioreserves. India has been a party to the bioreserves, but no legislations have come. So the point which I'm saying is that in this specialized kind of a tribunal, you can see that the whole emphasis which is being placed is solving the problem. Yes, there is politics. Yes, there is delay. I'm saying that, but at the same time, there is a positive move. And then the last one I'm going to say is there is a special bench which has been constituted, and that's where I have now started my research, which is very different. It's not existing in any part of the world, where it's a social justice bench. Environmental justice and social justice are intricately linked to each other. You know, when you have resources problem, poverty, as a consequence of environmental degradation, it becomes a social justice issue. The social justice bench of the Supreme Court is trying to ensure that there is a fulfillment of the end obligations which are taking place as a consequence of environmental degradation. And it again has come out with creative procedures which are cooperative, collaborative in nature, and they keep on monitoring as to when their judgments will be implemented. So the whole emphasis is being placed on implement the judgments that have been passed. So the cases which have come up in 2017 is Euro-compliant vehicles. You know, the cars or the vehicles have to be Euro-compliant. Disaster management plans need to be framed up. And the tribals who are affected as a consequence of displacement of dams need to be provided adequate compensation. So again, it's a very specialized tribunal based on collaboration that is really emerging in present day time. In the end, I would like to say that Anthropocene needs a very strong imaginative judiciary. The remedies have to go beyond the predetermined legal analysis. It has to create new procedures, and science should play a very important role. What is important is proactive approach, not judicial activism. The fine line of distinction is that in judicial activism, judges are always subjective. Judges are taking forward their own opinion, whereas in proactivism, you're talking of guardianship, you're talking of welfare of the people, social responsibility, and above all, environmental protection. India is a template for developing countries as well as for the developed world. It has taken few steps which are very positive, but that does not mean that all the problems are solved. There are 1.3 billion people. So when you have this kind of number, it takes time. it takes energy, it takes commitment and dedication to solve the problem. But having said that, I would still look at the positive side rather than the negative side. Thank you for your patience and attention. Thank you.